list.
That he gave me the list. I said to him, I conveyed the message of the prosecutor, and he conveyed to me he has no recollection of having given us or given me a list.
Okay. I guess let me leave it there for now. Thank you.
Thank you, commissioners. I would like us to consider, in relation to the issues under discussion now, the position you assumed before the ad hoc committee. And for that purpose, I would like to refer you to file 3. And in particular, if we could go to page 559. That is CJC 375, which starts at 523. That's a transcript of your testimony before the ad hoc committee.
Sorry, Counsel, you want me to go to page?
559. Now, let's start, it's not numbered, the lines, but you see the line that reads the committee adjourned for lunch.
That is correct.
I want to pick it up from there. Advocate Arendse says to you, we are dealing with a referral by Mr. Adams in terms of section 27. You said that apart from seeing him on television screen, you do not know him at all. You say that is correct. You did not receive the referral yourself when it was received by IDAC. That is correct. What is the date of that referral? The second week of November 2024. So before ad hoc, you suggested that you didn't receive the referral affidavit from Mr. Adams. The last 2 days before the commissioners here, you indicated that you received it and you actually triggered an internal process resulting in a section 2813 application for a preliminary investigation.
Correct.
The two are contradictory. Which is the true position? Is it what you stated to the ad hoc committee or what you are stating to this commission?
I took the question at the time to mean that I received it from Mr. Adams. That is why I prefaced it as I did by not knowing him. My office did receive the section 27. That is the position. I received a section 27 deposed to by Mr. Adams and dated the 21st of November 2024.
But how could you so understand when Mr. Arendse's question is very direct? You did not receive the referral yourself when it was received by IDAC. That's the question.
I did receive the referral.
And your answer to the ad hoc committee is, that is correct, I did not receive it.
That's what I took it to mean. That I did not receive it from Mr. Adams, but I did receive the referral.
Where then did you receive it from?
The referral, when it came in an envelope to IDAC, to the officers, through the nominal document receival process, and then it was submitted to my office.
Okay. So you received it from IDAC. That's what you wanted to clarify to Mr. Arendse. Didn't receive it directly from Mr. Adams by hand, you received it from IDAC.
Correct.
Okay, your engagement doesn't go that far. But let's move on. Yes.
Are you leaving that page?
I am not. I'm staying with the page.
No, let me leave you to do.
All right. Now, the second leg of your engagement with Mr. Arendse on this issue, towards the bottom of that page, Mr. Arendse says, you are not aware of Mr. Adams also referring this matter to the National Commissioner of Police, the National Commissioner or the Minister. You say, no, not at all. Do you see where I'm reading?
Yes.
But we know after our engagement yesterday that MK16 tells us otherwise. Your entire basis for being persuaded by the referral is precisely because you said these issues had been raised with the minister. The minister or the minister's office had purported to refer this matter to you in terms of section 27. We had quite a lengthy engagement, and you too, with the commissioners about what was the complaint to the minister, we suggested that it related to interference and interception. You insisted that it related to what is contained in the section 27. Going with your understanding, then it can be correct that you did not know that he had complained to the minister, because we know our annexure MK 16, which you confirmed you received, and you responded to, although you don't quite recall in what terms, tells us otherwise.
That is correct. At the time, I did not recall receiving anything from the office of the minister.
So why didn't you say, no, when did you say, I don't recall? You definitively say, no, not at all.
Not at all. Correct.
So what was ad hoc to believe? What if ad hoc believed that statement? You intended for ad hoc to rely on that statement.
That is correct. I did not recall remembering, that's stupid English. I did not recall receiving that from the office of the minister.
Yes, Commissioner, comment.
You see, Advocate Johnson, your testimony yesterday was that IDAC received the minister's letter, and the minister's letter was unhelpful. And you instructed Perumal to get an affidavit from Adams. Now, that's completely different to what you said to the ad hoc, because the impression you are creating here is that it is Adams who came to IDAC and this thing landed on IDAC's desk, when in fact yesterday we agreed that based on the minister's letter, or rather the letter from the minister's office, it is IDAC that reached out to Mr. Adams. So which is which now? Because here, it's Mr. Adams who's coming to IDAC, but yesterday you were quite clear that it's the minister who came to IDAC. The letter from the minister was not helpful. You then instructed Perumal to reach out to Adams, and that's how the Section 27 affidavit came about.
That is the correct position, Commissioner Khumalo. When I say that Mr. Adams came to IDAC, it is Mr. Adams who wanted IDAC to deal with his matter. But the position, as I indicated yesterday, is the position of having first received a letter from the minister. I did indicate that there were no attachments. I therefore asked Mr. Perumal to please engage Mr. Adams, as Mr. Adams wanted IDAC to deal with his matter.
So, and then the last engagement on that page, your response to the ad hoc gives the impression that Mr. Adams's referral landed on your desk in the middle of December 2024. Now that cannot be correct, because on the 6th of December, you gave the authorization, the Section 28 sub 13 authorization. So it cannot be correct that the referral landed on your desk in the middle of December 2024. Because that is the question. Advocate Arendse says, after the referral in November, when did the matter land on your desk and what work would have been done on it? So the question, although it's 3 questions in one, it is specific. When did the matter land on your desk? And your response is, at the time I received it, it would have been the middle of December 2024. That was incorrect, what you told the
This is incorrect, yes.
Because already by the 6th of December, you had had engagement not just with Perumal, but also with the prosecutor.
That is correct.
Because you would have, by the 6th of December already, looked at the application from the prosecutor and formed a view that you are going to authorize investigation into those 12 people that we mentioned earlier.
That is correct, Commissioner Khumalo.
Thank you.
But the question is, why did you say to the ad hoc committee that you received the Section 27 in the middle of December? Why would you say that?
At the time, Commissioner Baloy, that was my recollection. In coming to
carry on, sorry.
In coming to this commission, I had to offer myself properly with all of the facts. I'm not saying that the ad hoc was not important. I didn't go through all of this detail with my team when I went to ad hoc.
But you would have prepared to go to ad hoc. I mean,
Yes.
I suspect they will be deeply offended if they are to understand you to mean you went to that committee without preparing and looking at your records on this matter. So I must assume that you prepared when you went there. You knew what the issues were. There are terms of reference as in the question.
And my reading of 2813, why do you suggest it requires a designation? When I read 2813 with 28 sub 2 sub A, I draw a distinction. Whereas in it's 28 sub 2 sub A, that requires you to designate people to investigate. But that's a full-blown investigation now. 2813 doesn't do so, and if anything, it just simply says you, the investigating director, may hold a preparatory investigation. I accept for present purposes that you may delegate that power. But it doesn't require you to establish a whole team of people to investigate. It's preliminary.
I understand what you're saying, Council.
Yes.
But out of practice, we do designate persons to the investigation, preparatory or otherwise, or else it'll go back to Commissioner Beloy's point of you have people running around on fishing expeditions and doing as they please. And how do we account for what was done, who did it? Back to Commissioner Khumalo's question of how do you have people interviewing senior persons, etc. It is the designation assists in identifying persons to be able to conduct the activities that that team determines are for investigation. We have always done a designation for both so that there is accountability and there's responsibility for the activities and for the actions.
And I'll tell you perhaps where that designation in terms of 2813 gives me challenges. We have now agreed that you authorized a formal Section 28 investigation on the 30th of May.
That is correct.
That's when the investigation starts.
Incorrect.
Tell me.
So Section 2813 is a preparatory investigation. It allows you to take statements. It allows you to interview persons. It allows you to subpoena documents in terms of Section 28.6, which is what you would see the investigators had done.
Let's deal with that issue with reference to the wording of 2813. 2813 allows you, as the investigating director, it specifically singles you out, advocate, to hear evidence to enable you to determine if there are reasonable grounds to conduct an investigation. So it's a process to enable you to make a decision whether or not to investigate. Correct?
Correct.
Now, we know that on the 6th, you started the preparatory investigation, and by the 30th, you say there is sufficient material to conduct an investigation. So the actual investigation only starts from the 30th of May. Otherwise, you are investigating with while you are in the 2813 mode, and whatever exercise you are undertaking at 2813 determines whether or not you should investigate in the first place. So you can't have a full-blown investigation in 2813.
It's not a full-blown.
Okay. Now, we know that you came to the conclusion that we must investigate on the 30th of May as per the authorization. I don't know if this speaks to the efficiencies of IDAC. By the 26th of June, 2025, less than a month later, after you authorized the actual investigation, that list of people was arrested and appearing before court. So your investigation actually took exactly 3 weeks, not more. What did that investigation unearth that was already not in your files by the 30th of May?
The investigations out of that preparatory investigation would have commenced after the 6th of December 2024.
Yes.
And I do hear what you say, Counsel, but in terms of the preparatory investigation, I read it with Section 7.3 of the Act that says an investigating director shall be assisted in the exercise of his or her powers and the performance of his or her functions or duties, and lists those people. So it is not the investigating director herself who conducts the preparatory investigation. And the persons designated thereto conduct the investigation on behalf of the investigating director. We go back to what is allowed in terms of Section 28 as an investigative tool. They are allowed to interview witnesses. They are allowed to obtain subpoena and obtain documents, etc. And that is what had happened. So by the time we get to, if I can just take a moment,
Yes.
I'm just feeling slightly lightheaded.
Take a moment.
Yeah. Thank you, Chair. So by the time we get to the 30th of May, there would have been investigations done. What the test is on the 30th of May, in the presentation of the Section 28 application, is a summation of everything obtained to date. Does it now make or create that reasonable suspicion we say was not there in the initial phase? And if it therefore fulfills that requirement, we can then authorize the full-blown investigation.
Okay.
It doesn't mean... May I continue?
From what we are dealing with here. So you knew that the referral and your investigation and your arrest of General Khumalo and what General Mkhwanazi said on the 6th of July were at the heart of what they are investigating. So you cannot conceive of a situation where you did not go into your records of how this started, this are what culminates in prosecution. Where did it start? I can't, it's difficult to accept you saying I did not remember, when in fact a lot happened before the 6th of December. A lot. You activated things. You received a Section 2813 application. You authorized things to be done before the 6th of December. How can you make a mistake? How could you genuinely make a mistake that you received this referral middle of December? It's improbable that's what happened. It's improbable that you did not remember that you received this in November already, before the middle of December. In fact, here you say middle December. We know it's much earlier that you are actioning and making demand and signing those documents for people to be investigated. It's improbable that you didn't remember it. You can comment if you have any comment, but that's my view. It's just unbelievable that you did not remember when you answered the question.
I take your point, Commissioner.
Thank you.
Thank you, Commissioners. And staying with your testimony before the ad hoc committee, can we go to page 557? And just to introduce the issue, it starts at 557, bottom thereof. Advocate Arendt stating, you mentioned that you do not know, have never met Mr. Adams. You mentioned in your statement that when he approached IDAC, he had already gone twice to the subs in Western Cape and Gauteng province to open cases. Now we know that he didn't approach IDAC. IDAC approached him. We know that now for a fact. Do you confirm?
Correct.
And then Advocate Arendse continues, and then you say somewhat miraculously these cases disappeared. Now, do you have first-hand knowledge of this, or are you just conveying information that came to your knowledge at some point? Your response at 558 reads thus: this came to my knowledge through my own investigators who had taken the Section 27 referral affidavit from Mr. Adams. Part of what he indicates is that when he received information which he alleges was pushed under his door, which is part of the affidavit.
He says he received documents under his door.
Also, which is part of the affidavit is the allegation that...
Is the allegation.
But did you receive those documents? Were those documents disclosed to IDAC?
They were not part of the 27, and I'm not aware that any of those documents were disclosed to IDAC.
So you never received, you're not aware of receipt? No. Let's stay at page 558. At the bottom, Mr. Skosana says, did Mr. Adams bring up a classified document in this report? If so, are you authorized to investigate classified intelligence, and which specific section allows you to do so? According to the law, only the Inspector General of the Intelligence Office has the authority to investigate such matters. Your response is overleaf at the top of 559, wherein you state, what the ID herself received was a Section 28 application based on Section 27 referral. I'll pause there. When you say what the ID herself, you are the ID.
Correct.
Oh, so you are speaking of yourself in the third person. I shouldn't get confused. Okay. You continue. The investigators got an affidavit from Mr. Adams. Let us just say the ID was given a document purported to be classified. The ID is in possession of top secret clearance that therefore will allow me to look at those documents. However, before we do that, even with the State Security Agency matters to err on the side of caution, would indicate to the person giving us a document, can you rather declassify before you give it to us? But I did not have sight of any of the classified documents. Now, you say you received a Section 28 application based on the 27, and you say, let us say the ID was given a document purported to be classified. Are you suggesting that you were given a document that was purported to be classified, or are you saying it's a hypothetical example? Should you be given a document purporting to be classified?
It was a hypothetical example.
So you have not seen the content of the documents that were pushed under Mr. Adams' door?
Correct, I have not.
You remember yesterday, you relied on specifically those documents as a ground for the suspicion that Mr. Adams harbored. How could you when you haven't seen the actual documents?
I rely on what he says in his affidavit, that this is, I received information under my door, this is what the information said. So I relied on his affidavit. He didn't give us classified documents, or I didn't get any classified documents. Counsel, he refers to it. He says, documents having been pushed out under my door, I relied on that information. And of course, I think he goes on further to say he relied on other information he would have got.
No,